Hello everyone, I am Srinivas here. I am discussing today about the constitutional law. The topic directive principles have no more remain as the directions. On going through this video, you are able to understand number one, describe the significance of the directives, principles of the state policy and objects behind. Number two, understand the various directives as provided in Part 4 of the Constitution of India. Number three, explain the relationship between the directive principles and fundamental rights. Number four, elaborate the meaning and the concept of directive principles of the state policy. The concept of directive principles of state policy is an embodiment on the edifies the constitution of the country may be regarded as a fundamental law of the land pertaining to the institution of state government of that country. It delineates the powers and responsibilities of various instrumentalities of the state, imposes limitations upon them, and regulates the relationship between the state population. It embodies and even strives to construct a common national, political, and constitutional identity for the people. The concept of directive principles of the state policy, Part 4, Article 36 to 51 of the Constitution of India, contain the directive principles of state policy, that is DPSP. The DPSP contained in Part 4 of the Constitution set out the aims and objectives to be observed by the state in governance of the country. The concept of directive state policies, the idea of directive principles has been borrowed from the Irish Constitution, and the Irish government get it from the Spanish. The directive principles are the ideals which the government must keep in mind while it formulates the policy or passes any law. They embody the aims and objectives coming under this policy. Need for directives. The main objective behind the directive principles appears to have been to set standards of achievements before the legislature and the executive, the local and the other authorities. We are living in an era of a welfare state, not a police state, which seeks to promote the prosperity and well-being of the people. The makers of the Constitution are very now, the concept of directive principles of state policy, Part 4, the directive principles of the state policy contained in Part 4 of the Constitution set out the aims and objectives to be observed by a state in governance of the country. This concept of directive principles of state policy, the concept is the idea of the directive principles has been borrowed from the Irish Constitution, and the Irish Constitution, for repetition, they borrowed from the Spanish. The directive principles are the ideals which the government must keep in mind while it formulates the policies or passes any law. They embody the aims and the objectives of a welfare state and not a police state, as I told you earlier. The main objective behind the directive appears to have been such standards of achievements before the legislature and the executive and the local authorities. We are living in an era of welfare state which seeks to promote the prosperity and well-being of the people. The makers of the Constitution has realized that in a poor country like India, political democracy would be useless without a DPSP. Now, classification of directives. It can be number one, social and economic charter, number two, social security charter, and number three, community welfare charter. By dealing with these charters, number one charter, that is social and economic charter, contains a serial order based on justice, that is Article 38, and principles of policy to be followed by the state in security of economic justice, that is Article 39. Social security charter, participation of workers in management of industries, that is Article 43. Right to work, education and public assistance in certain cases, Article 41. Just and human conditions of work, Article 42. Living wage for workers, Article 43. Now, social economic charter, social order based on justice, that is Article 38. This directive reaffirms what has been declared in the preamble of the Constitution. The function of the republic is to secure inter alia social, economic, and political justice. To secure justice to the people under the law, courts with broad powers have been established in the country. Principles of policy to be followed by the state. Article 39. The Supreme Court has taken a recourse under Article 39A to interpret Article 21 to include therein the right to livelihood. The Supreme Court has observed in Volga Tellis versus Bombay Municipal Corporation 1986. Now coming into the articles which are coming under the second charter, that is Social Security Charter, we have Article 45, free and compulsory education for children, duty to raise the standard of living and improvement of health. Article 47, promotion of education and economic interest of the weaker sections. Article 46, and equal justice and free legal aid to economically backward classes. Article 39A. Community Welfare Charter, that is the third charter, what it describes about number 1, Uniform Civil Code. Article 44, Organization of the Agriculture and Animal Husbandry. Article 48, then Protection and Improvement of Forests. Protection of improvements of forests, that is Article 48A. Then now the principles of policy to be followed by state. Article 39. In a major pronouncement in Madhukishwar versus State of Bihar 1996, with a view to protect the economic interests of the tribal women depending on the agriculture for their livelihood, the Supreme Court has ruled that on the death of the last male holder in the agricultural family, the dependent female members of the family have the constitutional remedy of the continuing to the hold to the land so long as they remain dependent on it to earn their livelihood. Otherwise, the females will be rendered destitute. So this is a very important judgment under Article 39, and these DPSP are giving lifeblood to the fundamental rights, and they are complementary and not they are reversing or having a vice versa of the main aim of the Constitution. They are complementary, and as well as they are actually giving life to one another. As you know, the Constitution is the living and breathing document of India. Then coming to number 1 charter, that is Social Economic Charter, social order based on justice. Article 38. You know, I already spoke. The Supreme Court in Kasturi Lal versus State of Jammu and Kashmir 1980 has observed that if a law is made to further socio-economic justice, it in prima facie reasonable and in public order. Now, Article 39, the Supreme Court has taken a recourse on Article 39 to interpret Article 21 to include therein the right to livelihood. The Supreme Court has observed in Volga Telly versus Bombay Municipal Corporation case 1986. Now, coming to the Community Welfare Charter, had stopped at protection of monuments and places and objects of importance, Article 49. Now, again, for the sake of repetition, I have come to Article 39. In a major pronouncement in Madhukishwar State of versus State of Bihar 1996, with a view to protect the economic interests of the tribal women depending on agriculture for their livelihood, the Supreme Court has ruled that on the death of the last male member in an agricultural tribal family, the dependent family members of the family have the constitutional remedy of continuing to hold the land so long they remain dependent on it and earn their livelihood. Otherwise, the females will be rendered destitute, and destitution is a bane to the country. Now, principles of policy to be followed by state. Article 39. In state of Tamil Nadu versus L. Abu Khawar Bhai 1984, the Supreme Court has given an expansive interpretation to the word distribution in Article 39b. What exactly it says about Article 39B is brought here under the word, I quote, distribution does not merely mean that property of one should be taken over and distributed to others, like land reforms, where the lands from big landlords are taken away and given to landless laborers. That is only one of the modes of distribution, but not the only mode. So this is the judgment given, and principles of policy to be followed by the state under Article 39. Article 39C contemplates measures for preventing concentration of wealth and means and production in few private hands. Now, as you know, I had come to some of the articles which are coming under Community Welfare Charter. Among that, I stopped at Article 49. Now, there is Article 50, separation of judiciary from executive, and then 6, promotion of international peace and security, and organization of village panchayats. Now, Article 39C contemplates measures for preventing concentration of wealth and means of production in a few private hands. The Parliament has passed several constitutional amendments, and now coming to the second social economic charter, which has got some of the important articles, that is Article 43, Article 41, Article 43 again, and Article 42, then Article 45, Article 47, Article 46, and Article 39A. Equal justice and free legal aid to economically backward classes is brought in by Article 39A, which gives the socio-economic structure to become more bedrock. Right to work, education, and public assistance in certain cases, Article 41. Article 41 directs the state to ensure the people within the limits of its economic capacity and development, employment, education, and public assistance in cases of unemployment, old age, sickness, and disablement in any of these causes. Now, just and human conditions of the work, Article 42. It has brought all the that is enshrined in the Constitution, that is Article 21 is again translated and brought to living by this article. In Bandhuva Mukti Morcha versus Union of India 1984, the Supreme Court has given a clear verdict on how this now Article again 39, in major pronouncement in Mallukeshwar and state of Bihar, with a view to protect the economic interests of the tribal women depending on the agriculture for their livelihood. The Supreme Court has ruled that on the death of the last male holder, it's again for Article 41 again have come, and both are interrelated. Article 41 directs the state to ensure the people within the limits of its economic capacity and development, the employment, education, and public assistance in cases of unemployment, of old age, sickness, and disablement in other cases of undeserved want. Now, Article, as I told you, the just and human conditions of Article 42 in Bandhuva Mukti Morcha versus Union of India 1984, the Supreme Court secured the release of bonded labor and freed them from the exploitation. It is observed that it is not only the question of release of bonded labor, but also of their proper rehabilitation after release. The Supreme Court has insisted upon effective rehabilitation of freed bonded laborers. In this case, living wage workers. Article 43. State to secure and suitable legislation or economic organization or in other way, all workers, agricultural, industrial, and otherwise work a living wage, conditions of the work ensuring a decent standard life and full enjoyment of leisure and social and cultural opportunities. Now, participation of workers in management of industries brought under Article 43A. Under a capitalist economy, the ownership as well as the management of any industry or enterprise belongs to a particular individual who provides the capital. The workers are hired and only get wages from the capitalist who earns all profit and bears all the loss. This is exactly the Article 43A. Wherein Article 43 is the first active step towards the socialism in India. The scheme of 43A that though the ownership might belong to either to a private individual or to a state, the workers engaged in a particular industry or enterprise shall by legislation will be given a share in the management. Now, provision for early child care and education, that is Article 45. 45 is dealing with the child care, and it also have an emphasis on constitutional right, and now the right to education has become a fundamental right. The directive principles of the state policy, which Article 37 are expressly made unenforceable by courts and cannot override the provisions found in Part 3. Now, provisions for early childhood or care education, Article 45. Article 45 earlier required the state to make the provision within 10 years to free and compulsory education for all children up to age of 14 years. In Unni Krishnan vs. State of AP, the Supreme Court held that the right to education is a primary fundamental right. 86th Amendment 2002, old Article 45 substituted for a new Article 45 in consequence of right to education of children up to the age of 14 years having been raised to status of a fundamental right. Notwithstanding the other provisions are expressly made enforceable by appropriate writs, orders and directions under Article 32. Promotion of education and economic interests of the weaker sections, Article 46. In its concept, the words education and economic interest and the words in particular of scheduled castes and scheduled tribes, it would be legitimate to infer that the expression weaker sections refers to the sections of the people who, though do not belong to scheduled castes or tribes, are to be given prominence in education. Duty to raise standard of living and improvement of health under Article 47. The state shall regard the rising of the level of the nutrition and standard of living of its people and the improvement of public health as among its primary duties. Now, in our opinion, that is the correct approach in which the provision found in Parts 3 and Part 4 have to be understood. However, now, duty to raise the standard of living and improvement of health, Article 47, in state of Maharashtra versus Nagpur distilleries, All India Reporter 2006, Supreme Court 1987, held that 47 casts a duty on the state to reduce the liquor consumption. That means, now I'll come to the last one, that is this one, Community Welfare Charter, Uniform Civil Code, Article 44. The objective of this article to effect national integration by bringing all communities on the common platform on matters which are at present governed by diverse personal laws, marriage, divorce and maintenance. It is true that Goa government is having this Uniform Civil Code. Now, Article 44, the objective of the article is to effect national integration by bringing all communities on the common platform on matters which are present governed by the diverse personal laws, marriage, divorce and maintenance. In Sarla Mudgal versus Union of India 1995, the Supreme Court held that it is based on the concept of now organization of village panchayat. Article 40, it is the dream of the Gandhian philosophy. Article 40 requires the state to take steps to organize village panchayat and endow them with such powers and authority as may be necessary to enable them to function as units of self-government. This DPSP cannot be justiciable. Now, Uniform Civil Code, again we have some important aspect that I stopped earlier. In Sarla Mudgal versus Union of India 1995, the Supreme Court held that it is based on the concept that there is no necessary connection between the religion and personal law in a civilized society. This is the case law Now, Organization of Agriculture and Animal Husbandry, Article 48. Article 48 has accorded the recognition in somewhat guarded and hesitant form to the Hindu sentiment regarding cows under Article 48. To total ban on cow slaughter is possible, and this position has been accepted by the Supreme Court in Qureshi versus State of Bihar in 1958. While the test of usefulness has to be applied, extending protection to the other animals, it is not to be applied to cows. This is criticized by many anti-secular and uneconomic. Now, coming to Article 48, it is true that there is no violation of any fundamental right by applying a rule of that nature. Now, in Minerva Mills versus Union of India 1980, the Supreme Court 4-1 majority struck down the Act 31C as amended by the 42nd Amendment as unconstitutional on the ground that it destroys the basic features of the Constitution. And as you know, 42nd Amendment in 1974 is considered as the second mini constitution. Now, participation of workers in management of industries, Article 43A. Article 43A is the first active step towards the socialism in India. The scheme of Article 43A is that though the ownership might belong either to a private individual or to the state, the workers engaged in a particular industry or enterprise shall have a participation in shareholding. Then provision for early childhood care and education, Article 45. Article 45 earlier required the state to make the provision within 10 years to free the compulsory education for all children up to the age of 14 years. In Unni Krishnan versus State of AP 1993, the Supreme Court held that the right to education up to the age of 14 is a fundamental right. Duty to rise the standard of living and improvement of health, Article 47. In State of Maharashtra versus Nagpur Distilleries, All India Reporter 2006, Supreme Court 1986 held that the Article 47 casts a duty on the state to reduce the liquor consumption and keep the citizens of the country healthy. The directive principles of the state policy contained the Supreme Court, again Article 44, Uniform Civil Code, the Supreme Court has repeatedly regretted that Article 44 has so long as remained as a dead letter and recommended early legislation to implement it. The Supreme Court in John Valamanton versus Union of India, a judgment has been passed. Organization of Agriculture and Animal Husbandry, Article 48. Article 48 accorded recognition in somewhat guarded and hesitated form to the Hindu sentiment regarding cows. Under Article 48, total ban on cow slaughter is possible, and this position has been accepted by the Supreme Court in Qureshi versus State of Bihar 1958. Now, protection and improvement of forests and wildlife, Article 48A, the Supreme Court, Shri Sachidanand Pandey versus State of West Bengal, 1987, has clarified that whenever a problem of ecology is brought before the court, it is bound to keep in mind Article 48A and cannot leave the matter entirely to the government. Now, the protection and improvement of forests and wildlife, as I told you, 48A is a living example of protecting our ecology, the environment, and the environment is there, the whole human beings survive and flourish and thrive themselves. So, keeping in mind the Article 48A is giving a life or lifeblood to that important environmental. Now, protection of monuments and places, objects of the national importance, Article 49. Article 49 directs the state to protect every monument or place or object or artistic historic interest declared by under the law made by the Parliament to be national importance from spoliation, disfigurement, destruction, and other reasons. Now, destruction, removal, disposal, or export, as the case may be. So, protecting the national monuments is one of these endeavors that has been enshrined in the DPSP. And the Article 49 is very much clear that we have to protect our historic monuments and one who we have to see the history as our next footprints to follow. Now, separation of judiciary from executive. Article 50, it requires the state to separate the judiciary from public services of the state. This means that there shall be a separate judicial service free of executive control. Article 50 is based on the bedrock of principle of independence of the judiciary. Now, promotion of international peace and security has been brought under Article 51, and the state shall endeavor to promote international peace and security, maintain just and honorable relationship between the nations, foster respect for international law and treaty obligations in dealings of organized peoples with one another, and it's the idea of a welfare state envisaged in our constitution can only be achieved if the states endeavor implement them with a high secure moral duty. Now, justiciability of directives, Article 37 provides that the provisions contained in this part shall not be enforceable by any court, but the principles therein laid down are nevertheless fundamental in the governance of the country. It shall be and it shall be confer no rights or any person which can enforce in any court. Now again, it follows from Article 37 that directive principles impose no legal obligation on Parliament or state legislature to make laws complying with the directive principles and confer the reason behind the legal non-enforceability and non-justiciability of these principles is that they impose positive obligations on state while taking positive action. Government functions under several restraints, the most crucial of these being that of financial resources. Relationship between directive principles and fundamental rights. The directive principles differ from fundamental rights, which enjoin the state to refrain from taking prejudicial action against an individual and thus impose a negative duty on the state. Part 4, Articles 37 to 51 contains what may be described as positive obligations of the state. The state must secure a social order in which social, economic, and political justice must inform the institutions of national life. Wealth and its resources of production are not to be concentrated in the hands of a few, but must be distributed so as to subserve the common good. And there must be adequate means of livelihood for all and equal play, equal work. The state must endeavor to secure the health and strength of the workers and right to work, education, and assistance of want. Relationship between directive principles and fundamental rights is brought in as a slide. The directives are not enforceable in the courts. The directives are required to be implemented by legislation, and so long as there is no carrying out the policy laid down in a directive, neither the state nor the individual can violate any existing law or legal right. The directives per se do not confer upon or take away any legislative power from the appropriate legislature. Legislative competence must be sought from legislative lists contained in 7th schedule of the Constitution. The courts cannot declare any law as void on the ground that it contravenes any of the directive principles. The courts are not competent to compel the government to carry out any directive. Example, to provide for free compulsory education within the time limited by Article 45, or to provide adequate means of livelihood to every citizen, or to make any law to give effect to directive principles. Now, directive principles are not the directions, they are acting as fundamental rights as well. The courts are not competent to compel the government to carry out the directives to provide for free compulsory education within the time limited by Article 45, or to provide adequate means of livelihood to every citizen, or to make any law to give effect to directive principles is. Now, this judicial approach has been brought by several cases. One of such cases, Golaknath versus State of Punjab, All India Reporter 1967, Supreme Court 1643, is a manifestation of keeping distribution of wealth and The second one is Keshwananda Bharati versus State of Kerala, All India Reporter 1973, Supreme Court 1461 at 1641, has brought some of these important DPSP policies. The directive principles are fundamental in governance of the country. They are also known as positive rights or social rights. Now, State of Kerala versus N.M. Thomas, All India Reporter 1976, Supreme Court, page number 490, is also one of such important judgment came up in favor of DPSP, wherein the social and economic charter has been fulfilled. And as you know, the first case to come up so far as the first charter is concerned, that is Olga Tellis versus Bombay Municipal Corporation, All India Reporter 1986, Supreme Court 194, is describing about the social security charter. And the Minerva Mills versus Union of India, All India Reporter 1980, Supreme Court, page number 1789, is also a manifestation of community welfare charter, as well as the just and human conditions of the work, Article 42, and living wage for workers, Article 43. Article 31C and the directive principles. Article 31C, added by the Constitution, 25th Amendment Act 1971. The first part of the Article 31C provides that no law which is intended to give effect to the directive principles contained in Article 39B and C shall be deemed to be void on the grounds that it does not in fact give effect to such policy. So this is an article which was brought in the amendment by way of amendment. Later on, this Article 31C has been reviewed and interpreted by the Supreme Court of India. The second part of 31C provides that no law containing a declaration that is for the giving effect to such policy can be called in question on the ground that it does not in fact give effect to such policy. The validity of first part of the Article 31C was upheld in the fundamental rights case, but the second part of the article, which barred the judicial scrutiny of such laws, was struck down as unconstitutional by the Supreme Court of India. Article 31C was again amended in the Constitution 42nd Amendment Act 1976. It will be always be called a mini constitution. This amendment further widened the scope of Article 31C so far as to cover all DPSP for a purpose. The amendment substituted the words all or any of the principles laid down in Part 4 of the Constitution. The second part, as you know, it goes no law containing a declaration that it is for the giving effect to such policy can be called in question on ground that it does not in fact give effect to such policy has been struck down as